Hello, my name's Sangeelee and I'm a partner in the employment team at Edwin Co. I act for senior executives in high-value discrimination claims. And today, as part of our Proving Discrimination at Work series, I'm going to talk about how to best position yourself to achieve a settlement at an early stage. So there are three main factors for you to have in the front of your mind when you're entering into settlement discussions, and your employer will have these in mind also. The first is, what are the merits of your claims? Or from the employer's perspective, what's the extent of their potential liability? Then, what's the value of your claims? Or what should you reasonably be asking for in settlement discussions? And finally, what's your ability to litigate? Or from the employer's perspective, how likely is it that you will bring a claim in the tribunal? So in terms of the merits of your claim, it's important when you're asserting your claim to your employer that you do so in a considered way, that you're very clear about the acts of discrimination that you're relying on, and that you present any evidence that you have to support your claim. You can see that if you do this, your employer's mind is going to be much more focused on what its potential liability may be than if you take an aggressive approach, a scattergun approach, which is not properly thought through, in which case your employer is much more likely to be defensive and not really engage with the question of the potential risk of litigation. We've done a series of blogs and vlogs on this topic, so please do look back at those. But if you need any help with raising a grievance, then obviously get in touch. So in terms of the value of your claim, claims for discrimination are valued for the most part based on what your financial losses are going to be. Now, no one has a crystal ball. You don't know how long it will take you to get another job, but there are some factors which a tribunal will take into account. So market conditions are relevant. If you have a particularly niche job or a very senior job where those sorts of roles don't come available that often, that will be relevant. Perhaps your health has been affected by the discrimination you've suffered, or you otherwise have health issues which may make it more difficult for you to mitigate your losses. You might be quite close to retirement. These are all factors that the tribunal will take into account that would enable you to claim a longer period of loss than, for example, you may be able to in a straightforward unfair dismissal claim where compensation is capped at 1 year's pay or £105,000, whichever is the lower. And in a discrimination claim, you can recover not only your loss of salary, but also loss of bonus, carried interest, shares. So it can add up. But it is important to be realistic about the value of your claim and how quickly you think you'll walk into another role. You know, you can have the best claim in the world, but if you're going to get another job within your notice period or shortly thereafter, it's not going to be worth much. And so you need to think carefully about that so that going into settlement discussions, you can identify what your bottom line is. So in terms of your ability to bring a claim, there are two main elements to this. The first is time limits. So in the tribunal, you need to issue your claim within 3 months less 1 day of the act that you're complaining of. So it's not uncommon then for employers just to wait and see if you do that. And if you don't, you've lost your negotiating position. They don't need to worry about it. So it is important that you keep an eye on your time limits. There are some exceptions where you have a continuing act of discrimination, where there's a series of connected acts, then the time limit can run from the latest in that series. And you can also get an extension on just and equitable grounds if, for example, your health has prevented you from issuing your claim. But they're quite limited exceptions and the law around it's quite complex, so I would recommend you take legal advice before relying on those. The second factor is costs. It's no secret that litigation is expensive and employers tend to have deeper pockets than employees. But one way that you can mitigate against this is to get legal expenses insurance cover relating to employment disputes. This is often included in your home contents and buildings insurance, and if it's not automatically included, you can pay a small fee to have it as an add-on, and it really is worth doing. The limit on indemnity can often go up to £200,000, £300,000. And you can see that really levels the playing field when it comes to approaching litigation. And if you have that cover, we would always recommend you tell your employer that in settlement discussions, because then they know that cost alone isn't going to be a reason that you're not going to fight this. So if you're going into settlement discussions with your employer and would like some advice as to how to best position yourself, do get in touch. We're here to help.